smooth flow of our program. Please turn your mics off and turn your cams on. And also, you should accept that this meeting would be recorded. And as is previously said, this series of talks are conducted, implemented within the context of support for human rights program. And I would like to say welcome to you all once again, and I would like to deliver a brief introduction about Mrs. Idil Atak at first, and right after that, I will give the floor to her. Idil Atak is an associate professor and the graduate program director for the Department of Criminology in Ryerson University. She joined the Department of Criminology in 2013. She focuses on irregular migration, international human rights, and international migration law. And as of now, she studies on European Union Horizon 2022 research program. Under that program, UN International Migration and Refugee Compact and refugee system and the influences of that system on refugees. That project is conducted by 11 universities, and she is the director of that project in Canada. In addition to that, she also studies on forced migration, criminalization of migration, international security and migration, and there are a series of articles publicated by her. And in addition to academic studies, she also acted as the editor-in-chief of International Journal of Migration and Border Studies. She is also a member of the International Association for the Study of Forced Migration Executive Committee and the former president of the Canadian Association for Refugee and Forced Migration Studies, and also a research associate at Hans and Tamar Oppenheimer Chair in Public International Law, McGill University, and she also worked as a legal officer, legal expert in foreign affairs, Ministry of Foreign Affairs of Turkey, when Turkey followed up a more humanitarian policy, so to say, and she has a really very significant academic background on migration and refugee issues, which is supported by underfield studies as well. So her session will be really very enlightening for us all. I would like to thank to her for spending her time with us, for sharing her time with us under such an occupied agenda. And I would like to give the floor to her now. Thank you very much, Faizi, for this introduction. And I would like to thank the Kırkayak Association for inviting me, for having me. And I would like to say that it is a great pleasure to see you here, even though via online means, and interpretation service would be delivered, but my presentation will be in English. And if you would like to share anything, please interrupt me and jump in and ask your question immediately right in the course of the within the course of the presentation. Yeah, your question is either asked via Turkish or in English, and the presentation would become more interesting with your participation and interaction. And now I would like to continue my presentation in English, and I would be sharing my presentation in English. I would share that presentation with you right after that. And historical development and international refugee issue will be taken into account within the context of the presentation. And now I will ask a question to you. And now I will ask my first question. Right after now, the presentation would be carrying on in English language.
Hocam poll'dan ben açayım ister misiniz?
Açıldı
Çok iyi olur. Evet. Çok iyi olur çünkü.
You can see the poll now, I guess.
Birinci soruyu gösterebilirsen.
Could you please indicate the question 1?
Peki katılımcıların oy verme imkanı var mı Deniz?
Evet.
Tamam,
Soruları
o zaman
görüyoruz ama şeyleri göremiyoruz Damla. Nasıl seçim yapacağını. Yani seçme şeysi yok. Ya sorular var da oy verme şeysi yok.
Yeah, we could see the question and we could not vote for it. We could not join the polling. Let's do it like that. Let me ask question. Let me ask the first question. Maybe I could find an opportunity to show the second one via with options, with voting options. And
so we're talking about the International Refugee Law. This is the topic of today's discussion. When do you think this International Refugee Law started?
Can we speak?
Yes,
Or
please, go ahead.
Or should we choose from the... Oh, yeah, I guess it's starting after the Cold War I.
Mm-hmm.
I guess because I read some article about that. I'm not sure. I couldn't choose actually here, so I'm just to speak.
That's fine. No worries. Yeah, thank you so much. What do you think, the others? Do you agree with Ziad? Can we date back the emergence of the International Refugee Law to the First World War? What do you think?
Yani ben söz alabilirim belki. Birinci Dünya Savaşı değil ama İkinci Dünya Savaşı.
maybe I could step in. Maybe I could take the floor.
Sesim geliyor mu bilmiyorum.
Could you
Geliyor.
hear me? Yes, we can.
Yani aslında bu savaşlar boyunca da hani sığınma ihtiyacı
Indeed, during all those wars, people could be in need of sheltering, taking refuge, but the international status of refugees are recognized after Second World War, in my point of view. After Second World War.
Second World War, and I see the reasoning. Maybe I can now start sharing my screen, my slides with you. So here we go. Can you see my slides? All right. So here is briefly my outline. We will start with historical developments. Then we will speak about the International Refugee Regime. And then we will end with some current trends and challenges. So if I may go back to my question, when did the International Refugee Law emerge? Ziad, you were right. It's after this First World War. And as you can see on the screen, because there have been a lot of changes, geopolitical changes after the First World War, that's why. And to be honest, from the 16th century until the 1920s, for more than 4 centuries, there was little concerns about refugees. They did exist, but most European powers permitted uncontrolled immigration. So the rule was freedom of international movement. before the First World War and for more than four centuries. This is something that is really unimaginable now, given the current border controls and negative discourses against refugees and migrants in general. So things have changed after the First World War. This uncontrolled immigration, this freedom of international movement, this is something that has dramatically changed after the First World War. And so the collapse of three empires in Europe, and there were also major shifts in nation-state configurations and frontiers. And I think the map that you see on the screen summarizes some of these changes. And more importantly, there were massive displacement, massive number of refugees dislocated during the First World War. We've also seen after and during the First World War, the rise of nationalism, both political and economic nationalism, protectionism, borders, the importance of borders in the Western world. And as you may know, so this is a slide that illustrates this massive dislocation, human suffering during the First World War and after the First World War. And as you may know, the League of Nations, Milletler Cemiyeti, was established after the Second World War. This was an effort by the international community to prevent any more wars from happening. And between 1920 and 1950, the League of Nations, and there were also some other international bodies, have started to work on administering refugee protection. So that's why we can date the emergence of the International Refugee Regime back to the end of the First World War. We've seen a kind of codification of who a refugee is and what refugee rights are. And the League of Nations established the Office of the High Commissioner for Refugees. So the UNHCR that you know very well, I'm sure. The ancestor of the UNHCR was established under the League of Nations to deal with the question of legal status of these individuals who were dislocated, displaced from their homes, who found themselves without any state to protect them. So the League of Nations established the first Office of High Commissioner for Refugees to deal, again, I repeat myself, to deal with questions of legal status, repatriation, if possible, and also they coordinated relief operations, because this was an extremely vulnerable population, refugees, dislocated, displaced, stateless. And some of you may know the first commissioner, High Commissioner for Refugees, was Mr. Nansen. He was a very interesting person. He was from Norway. He was a Norwegian diplomat at that time, after the First World War. He was also a scientist and explorer. So he became the first commissioner for refugees under the League of Nations, this first Office of High Commissioner for Refugees established by the League of Nations. So there was this effort of, let's do something to deal with the situation of refugees. Let's help them. And the focus was, so we're talking about the first stage of refugee protection. We're talking about the International Refugee Protection Regime. 1920, 1939. And as you can see, I highlighted in the definition of who a refugee was at that time, I highlighted the word groups of persons. So this was a very different definition from the definition that we know of refugee today. So at that time, early 20th century, a refugee was a person who was a part of a group of persons. So this was this focus on the displacement and on the vulnerability of a group of persons. And they needed to be outside of their state of origin. And these were individuals who couldn't profit from the protection of their governments. Okay, but again, I insist on the words group of persons. And an example of this was this arrangement that you see on the screen that was about the certificate of identity for Russian refugees. Okay, so this certificate was issued to protect particularly Russian refugees. And as you may know, after the Russian Revolution in 1917 and following the First World War, there were a lot of Russians who were displaced. And we're talking approximately of 1.5 million of people, of Russians, fleeing destruction and suffering caused by the revolution. And many of these individuals were deprived of Russian citizenship. So they found themselves stateless. No Russian citizenship, no citizenship of any other country. So the effort of the international community, this International Office of High Commissioner under the League of Nations, was to issue certificates of identity for different groups of individuals, for instance, Russian refugees. Okay, so here are some photos, and this was called Passport Nansen. Nansen, remember, is the first commissioner, High Commissioner for Refugees. Okay, so the idea was that the League of Nations will provide these in collaboration with the country, of course. So these certificates would allow individuals to move from the countries that they seek refuge to other countries in order to seek better conditions of life. Okay, this was the idea. We will give them IDs, identification papers, and then they will be able to move freely and seek a refuge and then start a new life for themselves and for their families. All right, this was the idea. And Russians were not the only groups who were issued identification papers under the League of Nations. There were, of course, Armenians from the Ottoman Empire. There were also, let's say, Jews living in Eastern Europe who were displaced during the First World War, Montenegrins living in France. So many groups of refugees benefited from these efforts, including these certificates of identity. Okay, so after the Second World War, or during the Second World War, there was a shift towards from this group protection, instead of protecting Russians or Jews or Ruthenians, for example, there was a shift towards more individualistic approach to define a refugee. So the notion of refugee as we know it today, which is a very individualistic definition. It's not about a group of people, but it's about the individual who is a refugee for some reasons. We will discuss them. So this shift happened after the Second World War or during the Second World War, and slowly. A shift towards more individualist standards to define a refugee. And according to this shift, the refugee was defined as an individual and not a group, a person part of a group, but as an individual in search of an escape from perceived injustice or fundamental incompatibility with their home state. So these individuals cannot stay anymore within their home states because they are the target of injustices, or there is some fundamental incompatibility, and they have to flee their home countries and seek refuge. Okay, so these incompatibility can be for personal beliefs, personal characteristics, like being a Jewish person under the Nazi Germany. So what matters here is that there was this change from this group approach in terms of defining who a refugee is to a more individualistic approach to define a refugee. And so this Intergovernmental Committee on Refugees was established in 1938, to coordinate refugee aid organization. And also they facilitated involuntary immigration from Germany, Austria, especially of people fleeing Nazi persecution during the Second World War. This Intergovernmental Committee on Refugees, established in 1938. And the reason I'm highlighting this is that we will discuss shortly the UNHCR, United Nations High Commissioner for Refugees. But before UNHCR, there were many other efforts by the international community, by the League of Nations, and also by the United Nations established after the Second World War, to come up with some structures, with some institutions to protect displaced individuals. So UNHCR is not the first international effort, organization, structure to protect refugees. Okay, so that's why I'm insisting on these institutions. There were many other institutions before the Second World War, before UNHCR. An Intergovernmental Committee on Refugees did a really good job to save some of the individuals, refugees fleeing Nazi persecution. And they applied these personalized criteria when they helped refugees. So personalized criteria like political opinion, religious belief, racial origin, when they assessed the merits of refugee claims. So this is not something that emerged after, in the modern times. It was already happening during the Second World War. But the success of these efforts were, of course, limited. As you may know, millions of individuals were persecuted during the Second World War, displaced, and the efforts of the international community, like this International Committee on Refugees, were pretty limited. And the example I would like to give is the MS St. Louis. Are you familiar with this story of this boat, this ship? So in Canada, we use it a lot. Those of us who are teaching refugee or human rights law, we use this story a lot to illustrate the importance of human rights protection, the importance of refugee protection. Why? Because this boat called MS St. Louis departed from Hamburg in Germany in May 1939. So it was the start of the Second World War, 1939. And there were almost 1,000 refugees. To be more exact, there were 937 refugees on board of MS St. Louis. And they were, of course, you can imagine it, they were really desperate to leave persecution in Europe. And some lost their homes and business in Germany, in Austria, in other countries under the Nazi threat at that time, 1939. And MS St. Louis was bound for Cuba, and some of the passengers had their proper documentation. They had visas for Cuba. But when they arrived, they left Hamburg, Germany, and they sailed to Cuba. When they arrived Cuba, this was the very start of the Second World War, right? Cuban authorities said, "Oh, sorry, we cannot admit you. We can admit only a very, very limited number of these passengers. I think 30 of them were admitted only." And then Cuba turned the rest of the passengers and the boat away, said, "Go away, we cannot admit you, we cannot give you refugee status." Okay, so this boat and its passengers, more than 900 refugees, fleeing Nazi persecution, left Cuba and arrived to the United States. This was in June 1939. And again, they were denied entry because they didn't have proper documentation. And the US really was afraid of the diplomatic consequences of admitting, this important number of refugees, backlash from their public opinion, etc. You're familiar with these things, I'm sure. So the ship was returned, had no option but to sail to Canada. Cuba, US, and then Canada. And Canadian authorities also turned them away. They said, "Sorry, we cannot admit you, go back where you come from." Okay, so that's why, I systematically use this example in my courses just to illustrate how insensitive and somehow racist Canadian policies were in the Second World War. These individuals who were fleeing persecution were turned away and not being offered protection by the Canadian authorities at that time. So the ship returned its passengers back to Europe. 4 European countries agreed to admit these refugees, and unfortunately, 254 of its passengers later, during the Second World War, later died in the Holocaust. So I think this is a really, chilling story of, the consequences of denying protection to refugees. All right, so it also illustrates the limits of the efforts deployed by the international community at that time. All right, so I'll continue. As you may know, after the Second World War, the United Nations is established with the aim of being more successful than the League of Nations to prevent any more wars. The Charter of the United Nations was adopted in 1945, and I wanted to highlight the purposes of the United Nations. Article 1, this is the very first article of the United Nations, and it says that this new international organization will maintain international peace and stability and security. So this is the main aim of the United Nations. The protection of refugees is so fundamental, according to the United Nations at that time and still currently, to this notion of international peace and security. This is one thing I wanted to highlight. When you have millions of individuals suffering displacements, suffering marginalization, suffering discrimination, according to the United Nations, it is impossible to maintain international peace and security. It becomes an issue of security, human security, but also state security. That's why the United Nations established UNHCR, for instance. Okay, so this is something that I want you to keep in mind. There is no peace, there is no security for human beings, but also for states, without finding durable, lasting solutions to displacement, to human suffering by refugees. And the other thing I want to highlight, using this United Nations Charter, Article 1, is the importance of international cooperation. United Nations member states decided to cooperate to solve international problems of, as you can see, humanitarian character, social character, economic character, including refugees. The refugee issue. They also promised that they will respect human rights and fundamental freedoms of all without discrimination. So I think these are, powerful purposes. These are powerful aims of the international community, and they are still very, very current. And these are powerful arguments that we can make, for example, against the European Union. Why don't you cooperate to come up with lasting, constructive solutions to the issue of refugees? We can always go back to the purposes of the United Nations to make this argument. Because the international community and the states, including Turkey at that time, they were very much aware of the importance of these notions. All right, and then they established this International Refugee Organization, which was operational for a very short period, 5 years actually. What the International Refugee Organization did is to try to resettle tens of thousands of refugees and displaced persons during the Second World War and in the aftermath. So there were government selection schemes, employment placement, etc. These were parts of the efforts made by the International Refugee Organization to find some solutions to refugee issues at that time. So we're in the aftermath of the Second World War, right? But at the same time, the Second World War ended and the world entered fully within the Cold War period. In the Cold War period, this polarization between the Eastern Bloc and Western Bloc, the issue of refugees has been, or was very much polarizing, was very much politicized. So there was a lot of opposition to this International Refugee Organization's operation. That's why in 1950, United Nations decided to establish the UNHCR, United Nations High Commissioner for Refugees. I'm sure you are very much familiar with UNHCR. I know that some of you work with UNHCR. So this is an organization that was established in 1950. You can see an excerpt from the statute adopted by the United Nations General Assembly in 1950. So you can see on the screen that the mandate, the job of UNHCR, consists of seeking permanent solutions for the problem of refugees. And why? Because it is an issue, it is a, refugee issue is a problem, if not solved, for world peace, world stability, and security. That's why, UNHCR's main mandate is to seek permanent solutions. They collaborate with governments. They help governments to find permanent solutions to refugees. And so in Article 1 of the statute, it is referred to voluntary repatriation and also to the term assimilation. We don't use anymore the term assimilation, of course, but we prefer more integration. But at that time, the idea was to assimilate, integrate refugees as part of these permanent solutions. And the other thing to highlight is that the work of the High Commissioner is non-political. Why? Because we were in the Cold War setting. We didn't want refugee issue to be a divisive one, a polarizing one. So mentioning that UNHCR is a non-political organization aimed to calm down the Soviet bloc. And also it says it shall be humanitarian and social. All right. I have another question for you. I don't know if we are able to, I stop sharing my screen and see if you have any questions from, use the chat box. If you have any questions. Work, okay, that's fine. That's okay. So maybe I can ask you my question about UNHCR, which is, so as we've just discussed, UNHCR was established in 1950, right? And it was established for 3 years. You know, when the first, the statute was adopted by the United Nations said, okay, we will adopt it, but only for 3 years. So UNHCR, you have 3 years to solve the refugee problem globally, and then we will abolish UNHCR. We will not need it anymore. This was the idea. When UNHCR was established by the United Nations General Assembly, you know, you have 3 years to solve the problem, and then we will abolish it because we will not need it. All right. So its mandate was really very provisional. So my question for you, when did UNHCR obtain permanent status? When did it become a permanent agency of the United Nations? Because it was not permanent. The idea was, you know, you have 3 years, you solve the issue. Oh, that's great. Thank you, Deniz. Teşekkür ederim. So you have the question. Would you like to answer? There is, yeah, we cannot do the polling, but please feel free to jump in if you would like to answer. Cevap vermek istiyorsanız lütfen. Ne zaman? 1953, 1962, 1990, 2003. Ne zaman permanent oldu? Not anymore provisional, but permanent. UNHCR. ...1961. Teşekkür ederim Ziad. Ne diyorsunuz?
Thank you, Ziad. He said that the answer is 1961, 1962. Again, another answer, 1962. 1990. Another answer. 2003.
Until 2003, it was considered by the United Nations that oh, it's a provisional and not permanent agency. Yeah, the idea was, you know, we have 3 more years. We will solve the refugee issue. And then in 2003, they realized finally that the refugee issue is not going anywhere. It's not near to be resolved, and you know, durable solutions, etc. And they exactly. Geç kalmışlar kesinlikle Ergin.
Yeah, you are right. They are late. They are too late.
The idea was, you know, it's such a minor issue. We will solve it within 3 years, and it will go away. And then in 2003, they realized, no, it will not go away, and we need a permanent structure. So only in 2003 that the UN General Assembly said, okay, we will make it permanent, you know, more stable. So another question related to this one is about the budget, UNHCR bütçesi, okay? Where does this budget come from? So you see the options. Is it the United Nations that is funding the UNHCR, or states like Turkey, Canada, voluntary contributions from like me, you know, Burçin, by states, voluntary contributions. Hepsi, evet, Selin haklısın, hepsi, kesinlikle hepsi de. So it's funded.
Selin, you are right, all of the above.
Only, as far as I know, only 3%. Yeah, Yonca, you're also right. Voluntary contribution is the bulk, is the major contribution, monetary budget contribution comes from voluntary contributions. So voluntary contributions can be you, me, an organization like Kırkayak. It can be states voluntarily contributing. Only 3% of the UNHCR's budget comes from the United Nations. A very, very, very small portion. Okay, so when you ask yourself, why don't they have more means? Why don't have more tents to provide to individuals who are displaced? Why don't they have more medication, etc.? UNHCR. That's because they rely very, very heavily on voluntary contributions. And if you ask yourself why they are so cautious politically, why are not more vocal about refugee rights? Why are they condemning, Canada doing terrible things to refugees, like safe third country agreements or accelerated timelines to process refugees? If you have all these questions in mind, why don't UNHCR contribute more to refugees? Well, because the funding is dependent on these voluntary contributions. It doesn't have independent, secure funding coming from the United Nations. That's why they need to be very cautious when they speak up about a country's questionable policies or treatment of asylum seekers by states. It's a good question, Esma. Is this political choice? I would say because they don't have, all their operation relies on this funding that they receive through voluntary contributions. And they receive from states. They receive from the US, for example. And it was a disaster when Trump said, okay, we won't fund, we will reduce considerably funding for United Nations, including UNHCR. It was a disaster for UNHCR because it relies so heavily on voluntary contributions by states. And states can anytime say, I don't contribute to the budget of UNHCR anymore. That's why they are so cautious. That's why they say, oh, we are, and in their statute, as we've seen, it said it is a non-political organization. So they cannot, even when they give legal advice about, very controversial policies, like pushbacks at the borders, not assisting people who are drowning in the Mediterranean, in the Aegean, for example. UNHCR is always very cautious. Why? Because they are dependent. But first of all, it says in their statute that they are non-political, first of all. And second of all, because then they will not have any money. They will not be able to conduct their operations. I think that makes sense. So Esma, to answer your question, is it a political choice? It is, but it's also a legal constraint that they have. Yeah, humanitarian as an instrument in political arena. Yeah, Ziad, you're absolutely right as well. Yeah, it is politicized. And there is also this precedent of, what's its name? This international organization, which lived only for 5 years, and it was abolished because it was too political, taking sides, etc. That's why, yeah. Well, thank you for answering my questions. I will continue. I finished the first part of my presentation. I will continue But if you have any questions, feel free to unmute yourself and ask your question. Right? I think it really helps me and also your classmates as well. You know, having questions and me answering the question is also a good way of engaging. So, International Refugee Protection Regime. We're in the aftermath of the Second World War. Okay, Second World War, the United Nations Charter, remember the purposes, UNHCR is established, and at the same time, United Nations comes up with these conventions relating to the status of refugees. So there were a lot of efforts in terms of protecting human rights. You know, when we think about, for example, the establishment of the Council of Europe, the European Convention of Human Rights, it was also adopted in early 1950s. So this was a period where the international community, states, including Turkey, they were very eager not to repeat the errors of the past. And the idea was, you know, why don't we cooperate more? And establish international structures and come up with some principles. So that's why, for example, at the European level, the European Convention on Human Rights was adopted. And at the international level, which was not a refugee instrument, by the way, the European Convention, but it also protects some refugees, human rights in general. But at the UN level, there was this important convention. Refugee Convention was adopted in 1951. Okay, so if you want to learn about the International Refugee Regime today, well, you have to know your convention. Okay? It is not a very long legal instrument, but it is an extremely central, important instrument of refugee protection. And some scholars like James Hathaway, Guy Goodwin Gill, define the convention as a human rights instrument. So we will get back to this. Probably you know what's the difference between the convention relating to the status of refugees and the protocol adopted in 1967. When this convention was adopted in 1951, states could restrict their commitments to pre-1951 and restrict their commitments to European refugees. So there were these possibilities for states adopting this convention, saying, yes, I will comply with the principles that stem from this convention, to limit the scope and the application of the convention to refugees, so individuals who became refugees before 1951, and also limit these commitments to European refugees only. Okay, so it was a very Eurocentric instrument. But in 1967, this protocol came and allowed to lift these limitations. So this protocol didn't replace the 1951 convention, but just lifted these limitations, this geographic limitation and the time limitation. I hope this makes sense. But these instruments, Convention on relating to the status of refugees and the 1967 protocol, are ratified by a huge number of states globally. So more than 140 states ratified and said, we will comply with the principles of the convention and the protocol. So this is something that I think is important to highlight. Another thing I would like to say, and I'm sure many of you are familiar with that, Turkey was one of the drafters of the 1951 convention. So Turkey's representatives, they were involved in the drafting of the convention, and they played an important role in it. Okay, but then Turkey decided to ratify, to say, I will comply with the principles stemming from the convention, but with certain limitations. So, for example, today, Turkey accepts the convention principles and rights, but it applies the convention only to persons who have become refugees, in Europe. So there is a territorial limitation that Turkey still applies. All right. So what do we find in the 1951 Refugee Convention? We find all these things. First of all, we find a definition of who a refugee is. And it's a very important step in the protection of refugees. We find this inclusion, including the definition. We also find secession and exclusion clauses. So some provisions in the convention say who cannot be a refugee and who can cease to be a refugee. Right? I will not insist a lot on this, but I have a question for you. Maybe I can stop sharing my comments, my screen, sorry. And if Damla can put the question in the chat box. Thank you so much, Dennis. So here's a question just to illustrate the exclusion. Who can be excluded from refugee protection? The question is, Mr. X is involved in genocide in his home country. So Mr. X now says the new government of his home country is persecuting him for political reasons. Can this person flee his home country, let's say come to Turkey or to Canada and obtain refugee status? What do you think?
Involved in being, he was a part of this genocide, correct?
Involved in genocide. Yes, being part of genocide, absolutely.
Then he can't because he committed a crime against humanity, which excludes him from obtaining this human right.
Yes, thank you, Selin. Yes, you're absolutely right. So because it is genocide, it's part of these serious crimes that makes a person ineligible. So this person normally will be excluded from refugee protection. If the person is involved, was part of a genocide in their home countries, this person then cannot come to Canada and claim refugee status. They can, but they will be rejected. Why? Because it speaks to the exclusion clauses. So this is Article 1F of the 1951 Convention. Those who were involved in genocide, in crimes against humanity, in other sorts of really very serious crimes, and there is evidence that they were involved in these types of crimes, while they will not be able to benefit from the protection from safe haven, actually. So the aim of the international community is to make sure that those who are really, were involved in serious crime, those who are criminals, cannot benefit from protection anywhere, and they should face the consequences of their acts. Okay, they should be charged and tried, and they should be punished. This is the idea. I'm going back to my screen. So this exclusion clause makes sure that individuals involved in genocides and other serious crimes are excluded, cannot benefit from refugee status anywhere. So this is codified in the 1951 Convention, and there is a huge body of case law, depending on the states, about the exclusion. So we find inclusion, cessation, exclusion. We also find a lot of articles about the human rights of refugees. Then we find these two important principles. These are really the cornerstone of the International Refugee Protection Regime. No sanctions for irregular arrival, Article 31 of the Refugee Convention. And the other one is the principle of non-refoulement. So non-refoulement, I will get back to this. And I will have some examples for you if we have time. I hope so. So here we go. This is the famous definition of a refugee. And pay attention to the fact that this is an individualist definition. You know, I said in the First World War and after the First World War, the groups of refugees were protected. You know, Russians and Ruthenians and Jews were protected. And we've seen this shift towards individual approach. Okay, so this is very clear in the definition. And one of the main contributions of the 1951 Convention is to say to the states, here is the definition, you have to work with this definition when you give refugee status to asylum seekers. I highlighted different components of this very complex definition. I don't have time to go over each and every component of this definition, but I have some questions for you, and my hope is to clarify some of these components, as I said. Okay, I'll leave you the time to read. All right. I'll stop sharing, and I have some questions for you about the refugee definition. Dennis, if you can share question number 5. Yes. All right. So here is a question for you. I'm a high school teacher in Nigeria. I'm threatened by Boko Haram, which is a terrorist group. And I'm threatened because I'm a Christian, because of my religion. So I fled Nigeria after my house was burned down and after my father was killed by this terrorist organization. Can I obtain refugee status? Yes. Yes, I see the answers. Thank you. Okay. So in this, can one of you elaborate why? And how does this relate to the refugee definition we just saw on the screen? And you're absolutely right. You can maybe I can ask Ziad. Can I put you on the spot? Because you said no. Why do you think this person cannot get refugee status?
Yeah,
Ziad, would you like to?
Yeah, if I understood the question, actually, he are escaping from a group of military, let's say, or terrorism in his country. So there's a state and there's the governance. He can go to government and, let's say, can make complaint about this issue. No need to get refugee status and escape out of his country. This is my point of view. Because we are talking about specific group in this country, so no need to escape. And it's actually opposite what will happen in Syria. The government is, let's say, using the force against the people. So the Syrian people, they are escaping from Syria due to, let's say, the violence they are getting from the regime, Assad regime. So I guess this situation is opposite because they are small groups. They are, let's say, implementing or using the violence against this guy. So my point of view, he can go to his own, let's say, state and country to complain about the issue.
Okay, thank you so much. And this is really very important because first of all, I wanted to say that this person can claim refugee status because this person meets the criteria, one of the 5 grounds of persecution that we see on this definition. I don't want to share the screen, but so there are 5 grounds of persecution. If a person, claim refugee status, they need to meet one of these 5 grounds. Being persecuted based on their nationality, based on their race, or political opinion, or membership of a particular social group, or religion. In this case, he says, I am persecuted because I'm a Christian. So this person meets one of the grounds, which is good. So he ticks this box. Okay, he is persecuted, and he has a well-founded fear of persecution if he is sent back to Nigeria based on his religion. So this is one of the requirements. A refugee needs to prove that they will be persecuted if they are sent back home based on one of these grounds. And that's what he does. He says, I'm persecuted because of my religion, and religion is one of these persecution grounds that we see on the definition. All right, so the box is ticked for this. The other thing is the issue that Ziad raised. So when you read the definition, it doesn't say whether the persecution should be done by state, Nigeria, Nigerian military or police officers, and it doesn't say if the person, if the person is persecuted by non-state actors, whether this person can get refugee status or not. So this is something that was left open in the definition. We don't find this element included in the definition. But what happened is that after this convention was adopted, states started to implement their convention commitments. And also, I would like to share my slides with you to show this. The UNHCR also came up with a series of guidelines to clarify things that were not clear in the definition. Like, as Ziad said, if I am persecuted by non-state actors, what happens? Can I claim refugee status? Can I get refugee status? So this is a question that was clarified, first of all, by states. Each individual state decides in its own case law, decisions about refugees. And second of all, by these handbooks and guidelines developed by the UNHCR. So these handbook, the second one, is really very central. If you want to understand the different components of this very complex definition of who a refugee is, I would highly recommend that you read this handbook by UNHCR. The handbook clarifies the fact that in the example I gave to you, this person fleeing persecution by Boko Haram, a non-state actor, can get refugee status, even though the persecution is not perpetrated by the state actors. Okay, but I agree with you, Ziad, it's not clear at all in the definition. When you read the definition, it doesn't say us much about this. But when you read the handbooks and guides, and there are a number of guides issued by UNHCR over the years, and some of them are on these issues actually. You will see that as a response to my question, this person in Nigeria fleeing persecution by Boko Haram can get refugee status, even though they are not persecuted by Nigerian authorities. Okay, I have another question, and absolutely, Selin, you're right. The other thing is that in this case, Nigeria, the state was not able to offer effective protection to this poor guy. This is another factor that one should keep in mind. Here's another example, which is close to the first one. This case, we're looking at a Mexican citizen, a woman. My husband regularly beats me. As a result, I was hospitalized several times. So a woman who is ill-treated regularly by her husband, the police refuse to protect me and tell me to go back to my husband. You know, and this person fled Mexico, came to Canada. Can I obtain refugee status? What do you think? Yeah. Yes. Perfect. I have some no's. Ziad, I wasn't able to convince you. So the answer is yes. Why? And thank you, Selin. Obviously, you are an expert. So this person also fulfills one of the persecution grounds. It's not about race, it's not about political opinion, it's not about nationality, but she is persecuted based on her membership of a particular social group. She is a woman, and a woman can be decided, so gender-based discrimination can be a cause for refugee protection. She's a woman, so she ticked the box of one of the 5 grounds of persecution. And the other thing is she is persecuted not by the Mexican authorities, she is persecuted by her husband. Okay, so non-state actor, once again. She can obtain refugee status. Why? Because Mexican state is unwilling or unable to protect her. Okay, so not necessarily state actors need to be involved in persecution, need to be the source of persecution. The persecution can be done by a non-state actor, by a husband or partner. It can be done by a armed group like Boko Haram. If in the country, like in Nigeria or in Mexico, the authorities, the police, the court system is unwilling, or they're just dismissing my claim and they're just sending back me home to my abusive husband. If that's the case, they're unwilling to protect me or unable to protect me because there is a gang war and the army cannot go in Mexico. That's happening. Then I have a good refugee claim. I can obtain refugee status in Canada, according to these guidelines, according to state jurisprudence as well. All right. Oh, maybe I have another question. Thank you, Dennis. So in this case, I'm a citizen in an island state, in the Pacific, for example, ocean. And the ocean, because of the climate change, is slowly being submerged by the Pacific Ocean, okay? And I know that in, 5 years, I will have nowhere else to live. So there's an emergency, I flee my home. Can I obtain refugee status? If you refer to this refugee convention, if I am a climate refugee, environmental refugee, iklim mültecileri, evet. But I refer to the definition in 1951 convention. Yeah, so I cannot obtain refugee status according to 1951 convention, as Selin says, she's right. I cannot obtain. So also keep in mind that this convention was drafted after the Second World War. So keep in mind this context. The idea was to protect displaced individuals in Europe and displaced because of war and discrimination observed during the war. So the climate change, environmental change was not an issue at all at that time. And that's why we see the 5 grounds of persecution, race, rationality, etc. They're very restrictive, and it cannot cover issues like climate refugees. This is one of the shortcomings of the 1951 convention. All right, but there are some regional developments. In Africa, the African Union adopted in 1969 this convention, and also in the Americas, a bit later in the 1980s. Why these regional developments? It's precisely because states in these and individuals in these regions, Africa and the Americas, they realized that the definition of the 1951 convention was very, very limited, very restrictive to these 5 grounds of persecution. That's why it was a way, it was a response from them. And the other thing was also the context at that time. This was the post-colonial context in Africa. When you read their definition of these regional instruments, refugee protection instruments, you will see that their definition of refugee also include people fleeing external aggression, occupation, foreign domination, events seriously disturbing order. So it's much wider than the 1951 convention. And this was a reaction to the limited nature of the 1951 convention definition. For example, when you look at what's going on with Venezuelan refugees in Latin America, Southern America, you can easily realize how some countries like Colombia, Ecuador have been very generous with these Venezuelan refugees, fleeing a disastrous government since more than 5 years now, and it generated millions of Venezuelan refugees, and many were welcomed by the neighboring countries. So in certain contexts, certain continents, including in the Americas, they have a more, I would say, generous, broader conception of who a refugee is. So they don't restrict themselves to the 1951 refugee definition. And I'm sure you are familiar with this notion of common European asylum system, the infamous Dublin Convention regulations, right? So these are also parts of the regional developments. Today, Europe has a very sophisticated asylum system. They do implement the 1951 convention and the principles that stem from it, but it's something much broader. They have reception regulations, they have directives, qualification, etc. So very sophisticated regime that they have in Europe, and also, restrictive, pretty restrictive. And all the European directives have been interpreted by the Court of Justice of the European Union and by the European Court of Human Rights as well. All right. So 1951 convention is according some leading academics, is a human rights instrument. So when you read the 1951 convention, what you will find is a series of human rights. And it's, when you read it, each time when I read it, I find it pretty confusing. The way the rights, who can obtain some rights, etc., is pretty confusing, I would say, because these rights, these human rights, are organized under a system of levels of attachment. So when a refugee arrives in a country like Turkey, they do have some rights. Okay, because they are physically present. They do have some fundamental human rights, like they can access courts, they can have protection against refoulement, they cannot be sent back to persecution, etc. But then they can have access to more rights as they get these condition of being lawfully present in the state. And as their being lawfully present becomes longer and longer, as they established relations with the state, they have more and more human rights. Okay, so when you read the list of the human rights available to refugees, you will see that some of these rights are only owed to refugees who are lawfully staying, durable residence in the asylum country, like housing and employment, etc. So the more they establish relationships, legal, social relationships with the host country, the more they will have rights, especially the social and economic rights. So if you have any questions, I'm happy to answer them. But first, I would like to go over two very important principles that stem from the 1951 Convention. And one of them is Article 31, which says, states shall not impose penalties on refugees, on asylum seekers, if these asylum seekers arrive illegally, or if they reside illegally in that state. Okay, so the convention allows asylum seekers to arrive to the asylum country illegally. Crossing the border illegally is allowed, and also staying illegally is allowed, provided these individuals present themselves to the authorities and show good cause. Okay, so and the convention say to states, you should not penalize asylum seekers because they come irregularly. They cross the border illegally or with the help of a smuggler. Please do not impose any penalties. But the condition is that they have to present themselves to authorities and show good cause, saying that, hey, I need your protection. And I had to, it was an emergency. I had to flee without my papers, and I had to cross the border illegally. But now I am in front of you, and I am looking for your protection. So the convention says in its Article 31, if asylum seekers behave like this, you shouldn't penalize them. You shouldn't detain them. You shouldn't push them back to where they come. So this is a really very fundamental principle set forth in the 1951 Convention. So this is, of course, the principle we see, even in Canada, which is, respecting refugees' rights, etc. We see many instances where asylum seekers who arrive illegally to Canada, from the US to Canada, are detained, for long periods of time. And it's something that also impedes their refugee application. So unfortunately, states do not really comply with this requirement, but it is there. It is important. And I think, refugee advocates, civil society organizations, lawyers, practitioners, etc., keep saying this to states, and states shall not impose penalties on account of illegal entry or presence. And the other one, which is a very famous principle, it's called non-refoulement. It's a French word. And according to this principle, this is Article 33 of the 1951 Convention, it's a prohibition of sending an individual, an asylum seeker, back to a place where this person will be persecuted. Okay, so it is a prohibition of sending an individual back to persecution, back to arbitrary detention, okay, back to life-threatening conditions.
Hocam özür dilerim.
Evet.
Sorry to interrupt. Could you hear me? I have to interrupt you. I raised my hand, but I think you couldn't recognize it. I would like to ask a question. I think that it makes sense. You all know that there are some geographical limitations of Turkey, and due to such constraints or limitations, Turkey do not give refugee status to Syrians. Instead of them, they are provided with temporary protection status. And I would like to ask a question with regard to non-refoulement principle. We saw some news in 2015 to 2016 about that topic. For example, I have an example in my mind. Some Syrians were asked for identity cards on the street in Istanbul, on streets of Istanbul. Perhaps that Syrian could only went to the market for buying a bread, so he or she didn't take the identity card together with him, her, and they are sent back to the border. They were subject to unhumanitarian treatment, non-humanitarian treatment, or inhumane treatment, and those people were deported, and I couldn't understand a certain point here. Uh, Turkey do not award those Syrians, grant those Syrians or provide those Syrians with refugee status. So does Turkey have the right of refoulement for those Syrians just because they are not provided with refugee status, but they are provided with temporary protection only?
The principle of non-refoulement, it is considered to be the cornerstone of the International Refugee Protection Regime. It is also the cornerstone of the International Human Rights Regime. So it doesn't only apply to refugees, those who are individuals who have the refugee status. It doesn't apply only to asylum seekers. It applies to anyone. You may be familiar with the European Court of Human Rights case law. So the European Court of Human Rights in 1990s, or it was maybe late 1980s, came up with a decision called Söring. And the Söring decision was about a person from the United States who committed a crime. It was a murder. He was suspected of, being committed a murder in the U.S. and who fled from the U.S. to the U.K., if I remember it well, to Europe. So this person was not a refugee. This person was not an asylum seeker. This person was under the suspicion of committing a crime in the U.S. And the European Court of Human Rights decision said that the UK, United Kingdom, was under the obligation of not sending this person back to the US. Why? Because it would amount to a breach of the principle of non-refoulement. It would amount to a refoulement. So it applies to anyone, including individuals who committed a crime or suspected of being committed a crime. And the reasoning of the European Court was based on the fact that this individual, if sent back to the US, will be facing death penalty. So this person, if refoulement to the United States, would be at risk of losing his life. So since, I would say, the late 1980s, there is a well-established understanding, a case law in Europe, and also in North America, I would say. And so Turkey is part of Europe. The European Convention of Human Rights applies to Turkey, since for a long time now. The non-refoulement principle applies to anyone, including those who were suspected of, committed a crime in their home countries. Does this answer your question? So it is an international and domestic human rights obligation. And there are also some countries that, and also academics who consider non-refoulement as part of the customary international law. So there could be no exceptions. They should be applied, implemented by all states at all times. So it's not only for asylum seekers and refugees, but for everyone. For example, I live in Canada. Let's say I don't have Canadian citizenship, but there's a warrant against me in my home country, let's say Burundi. Well, Canada cannot send me back to Burundi if there is a risk for me to face death penalty or arbitrary detention in Burundi. Okay, so it applies to everyone. Why? Because it is a principle of general human rights law. And the other thing I think you highlighted, and it's very important to underline once again. So Turkey is part of these European human rights protection framework. The European Convention of Human Rights and European Court jurisprudence, the case law, applies to Turkey. And one of the main principles of this case law of the European Court of Human Rights is the principle of non-refoulement. Okay? A person cannot be sent back to persecution, to death penalty. Another reason for this is, as you may know, Europe is a death penalty-free area. There is no death penalty implemented in any European Union or Council of Europe member states, 47 member states, including Russia. And there is an obligation for these states not to impose not to put a person in a state or in a condition where this person will face death penalty in another country. Okay, so it is a very important criteria, principle, the non-refoulement principle, and it applies to everyone. And thanks for giving me the opportunity to clarify this. Teşekkür ederim Feyzi. Yarım saat uzatmak. If you can stay with me, I'm really happy to continue this discussion, and it will allow you to answer your questions as well. Deniz, I had a question about this. All right. Yeah. Let's do this. As you can see in the chat box, an asylum seeker from Bangladesh in this case is intercepted in the Mediterranean by Italy, and this person is returned to Libya. Can this amount to refoulement? Is it a breach of the non-refoulement principle? What do you think? So the thing that I would like to highlight here is that the person was not intercepted or arrested in Italy by Italian authorities, but in the Mediterranean. So can Italian authorities intercept this person and return this asylum seeker from Bangladesh to Libya without violating the principle of non-refoulement? What do you think? Selin?
I believe yes. Although there are many agreements between Italy and Libya, considering it somewhat safe, or some arrangements with the authorities, still, this person may not be safe in Libya. In that case, it does breach the non-refoulement principle.
Absolutely. Thank you so much. Yes, you're absolutely right. So even though the interception by Italy didn't happen on the Italian territory, this scenario would breach the non-refoulement principle. Why? Because Italy is responsible for this person being returned to Libya, and being returned possibly to persecution, or not being able to access protection. Okay, so this would amount to refoulement. There is a very famous European Court of Human Rights case, which is called Hirsi Jama. I can put the so here's the Hirsi Jama case that says this. So even though it happened, everything happened in the Mediterranean, not under the territorial jurisdiction of the Italian authorities, this can amount to non-refoulement. Italy is responsible in terms of offering protection to this person, and Italy cannot return this person back to the transit country, which is Libya. Okay. So Hirsi Jama case clarifies the notion of non-refoulement and the notion of jurisdiction when a state is responsible of a human rights breach. All right. Going back to my screen, the thing I would like to discuss with you is that, or maybe before I share this, I can ask you, the question is, does the convention, 1951 convention, impose any requirements for states to establish a refugee status procedure? Do you see anything in the 1951 convention that tells states, you know, you should have a court, or you should have your police, or you should have, you know, UNHCR doing the refugee protection? Is there any requirement in the 1951 convention? Anyone? So there is no requirement. When you read the 1951 convention, it doesn't tell states what to do. All it tells states is, here are the rights for refugees. Here are you know, the rights available to those who are legally present, legally residing, non-discrimination, etc. There's another thing that says to states, you know, cooperate with UNHCR to find durable, lasting solutions. But there is nothing in the Refugee Convention that says to states, you know, here is how you should proceed to determine refugee status. And I wanted to give you the example of Canada. In Canada, we have this tribunal, which is an administrative tribunal, which is called the Immigration and Refugee Board of Canada, that the Canadian authorities established, but pretty recently. So this administrative tribunal was established only in 1989, following a Supreme Court decision that said, you know, we now need a court, a professional body, judicial body to examine refugee claims. But there is no requirement in the 1951 convention telling states what to do. It was the decision by the Canadian authorities, and they were, you know, their arm was twisted by the Supreme Court of Canada, which highlighted the violations of human rights of refugees, you know, access to procedures, access to justice. And then this Immigration and Refugee Board was established by Canadian authorities, as I said, pretty recently. So when you look at the, you know, globally, different countries have different ways, different institutions established to examine refugee claims. And they decide, they are sovereign in terms of deciding whether it's the police, whether it's the Ministry of Immigration or İçişleri Bakanlığı, whether it's the UNHCR, who will examine the refugee claims. So there is some flexibility, but there is also a lot of different kinds of practices and laws across the globe. So this is one of the weaknesses of the International Refugee Regime. You see a whole different kinds of practices and institutions. All right, so one of the things that you find in the 1951 Convention and in the policy documents by UNHCR, for example, is this idea of permanent solutions. You know, if I can go back to the Charter of the United Nations. Remember, we want to keep peace, we want to preserve security, stability, and for that purpose, we have to collaborate internationally, we have to find common solutions, you know, acceptable solutions to problems like those of humanitarian character, like refugee issues. These permanent solutions are as follows. You can see on the screen. One of them is voluntary repatriation. Many of you mentioned the Syrian refugees in Turkey, right? So voluntary repatriation would mean that Syrian refugees, if they want, if they are ready, voluntarily and in conditions of security, can return to their home to their homes. So this is the first of the three permanent solutions. This is really a part of the UNHCR jargon, these permanent solutions for refugees. And the first one is voluntary repatriation. I insist on conditions of security. If the conditions are safe enough, secure enough in their homes, you know, villages, cities, then if they wish, Syrian refugees can be voluntarily repatriated. And there is, under the UN umbrella, some institutions, organizations that also help UNHCR and national authorities to make this happen. The second is local integration. You know, in case of Syrian refugees, this would mean that Syrian refugees would be successfully integrated in Turkey. This is local integration. And resettlement, I think in Turkish is üçüncü ülkeye yerleştirme. And as you may know, the US and Canada and Australia are the first, you know, three countries of resettlement. So these are the three permanent solutions for refugees. And I know that in this week and the next week, you will discuss a lot these contemporary trends and challenges. And one of these challenges, a huge challenge, is the very limited nature of permanent solutions to refugees. And I know that you are very familiar with this, because you live in Turkey. Many of you are involved in research, in advocacy. You have extensive experience with refugees, some of you. So you know these, you are familiar with these contemporary trends and challenges. You also know these figures, and it's really, you know, shocking to see that within 10 years, the number of refugees more than doubled. It is a really, you know, really shocking figure. And more than half of the refugees are children. So it speaks to the thing that the UN, you know, we talked about the non-permanent nature of UNHCR. It really doesn't make sense in a context where we see the number of refugees, displaced individuals increase steadily. And also the vulnerability of these displaced individuals. And we're talking about, you know, lost generations. More than, you know, half of the population is children. And this also, you know it, you know, I use these information in my classes because we're in Canada, we're, you know, geographically protected from these, you know, from this reality. We don't realize that regions like, you know, Pakistan, Iran, some countries in Africa, Turkey, Lebanon, you know, these are developing countries that are already struggling with their own economic, social issues, and they host 85% of refugees under the UNHCR mandate. And this is also something extremely shocking to me, and the inability of the international community to come up with realistic solutions. You know, why don't they make this international cooperation, responsibility sharing framework that is highlighted in the UN Charter? You know, the UN Charter says if you don't find solutions, this will threaten peace and stability and security, individual security and state security. So this, you know, in this course or training, you will be having the opportunity of, you know, examining many of these challenges, I'm sure. But I want to highlight some of them. And one of them is resettlement. The number of resettlement is very, very tiny. And we see a decrease, even a decrease in the number of üçüncü ülke yerleştirme. If we compare the figures of 2016 with the figures of 2019. And, you know, under the Trump administration, the United States closed its doors because they are sovereign, they can do it. You know, and you can see the impact of a racist, you know, hostile administration, hostile to refugees, and what it can do in terms of one of the permanent solutions, one of these durable solutions. And Canada is very proud of you know, admitting resettled refugees, but compared with the millions of refugees Turkey and other countries in developing world admits, I think it's really a drop in the ocean. It is good. It is important. I mean, Canadian authorities should be encouraged. And as you will probably see in your training, Canada also involves private individuals in this resettlement efforts, and this is great. But, you know, we can do more in terms of responsibility sharing for sure. So all this, I'm saying this because the durable solutions, the permanent solutions do not work well. There are a lot of shortcomings. There are a lot of issues, and we're in a state of perpetual migration crisis. You know, so-called migration crisis. I remember I started my PhD studies in early 2000s. You know, it was I think 2004, and there were already, you know, in the media and the political discourse, a lot of references to refugee crisis at that time. You know, there were a lot of Africans crossing to Canary Islands and etc. And since then, it's been almost 20 years. It never stopped. You know, we're in a state of perpetual refugee crisis. And the reason why is that the 1951 Convention principles are not fully implemented by states, and states also do not take it seriously, their obligations under the convention to find durable solutions to refugees. And there have been some responses to these so-called refugee or migrant crisis. In 2000, there was an initiative the UNHCR took called Convention Plus. I don't have any slides on this, but the most recent initiative, you know, in terms of international refugee protection, was this one, adopted, you know, the New York Declaration, and this was right after the 2015 so-called migration crisis. states got together under the auspices of the United Nations and adopted this New York Declaration. They said, well, we need to do something about it. Let's join our efforts and do something to address refugee issues. Okay, so this was the latest serious effort by the international community to somehow reform the system. And as you can see on the slide, the New York Declaration, which was adopted by states, right? They underline the issues in terms of access to asylum, borders closing, detention, legal and procedural limitations to block the access to protection. And so they're very, I would say, lucid in terms of these issues. And they came up with this comprehensive refugee response framework. So those of you who would like to know more about these recent developments in the International Refugee Protection Regime, I would recommend that you read the Comprehensive Refugee Response Framework and also read the Global Compact on Refugees. The Global Compact for Refugees was adopted in 2018. It is a non-legally binding instrument, so it's nothing like the 1951 Refugee Convention. We still have the 1951 Refugee Convention, but this Global Compact was adopted in 2018, as an effort to come up with some solutions, raising awareness. What could we do, to address refugee issue was the main question. And there is nothing new, but it's just a reminder of the commitments of states. Let's ease pressures on host countries like Turkey. Let's share the responsibility with them is one of the objectives. So, which is good, right? It is now a political commitment. Enhance refugee reliance, let them work, let them take an employment, let them study, let them, have businesses. Social security is another way of enhancing refugee reliance, and more resettlement, expand access to third country solutions. So there are currently talks about how states, including Turkey, should be more involved, engaged in the implementation of these global compacts. Okay, so to conclude, I would like to repeat what I said about the importance of refugee protection for peace and security globally, in our own countries, but also globally. And it's a matter of human rights protection. So it's not only for asylum seekers, but it is how a society defines itself. So if we, other asylum seekers, refugees, if we discriminate against them, it also tells us something about us as a whole, as a country, as a society. And this was the idea behind the 1951 Convention. Again. And the other thing is this movement of persons, because many states now are completely obsessed by borders and limiting the movement of individuals, migrants and refugees, asylum seekers. When you go back to the early stages of the refugee protection, the International Refugee Protection Regime, but the aim was to facilitate movement. The non-send passport was about giving them IDs so that they can move freely and then they can establish somewhere where they can flourish, they can have a better life for themselves and for their kids. So this is something we tend to forget. Asylum seekers need this movement, freedom of movement, to be able to integrate, to be able to start a new life. Otherwise, it is counterproductive. It doesn't work. Limiting their freedom of movement and other rights is counterproductive. It doesn't work. We go from one migration crisis to another. It doesn't work. And so the last thing I would say is that we have a very sophisticated legal framework depending on states. And I know that in Turkey as well, this is a framework that is developing, that is becoming more and more complex and sophisticated. And we're also evolving in Turkey within this legal framework of the European Convention of Human Rights. I think it has some impact, some positive impact, I hope. But we are also in a context of nativist and populist national discourses and policies. So there's a lot of pushback for the implementation of the rights set forth in the 1951 Convention. And lack of international solidarity, of course, you are very familiar with that. And I will stop here. Thank you so much for your patience.
Thank you very much, İdil. Bilmiyorum, sorular var mı? Hemen hemen süremizin sonuna aslında biraz geçtik.
We run out of time already. I am not sure if we have any questions because those sessions should be limited with 1.5 hours at most, at the latest, because some of us are also fasting. We would like to wrap it up in the shortest convenience. Anyone who would like to raise any question to Mrs. İdil amongst our participants, attendees? Yes, I would like to ask a question. Please go ahead. I would like to ask a question to Mrs. İdil. Italian case, which you made a mention of previously. I elaborated Turkey. You know that on 28th of February 2020, Turkey opened its borders for irregular asylum seekers, including Syrians. So Edirne border gate was opened by Turkey, and those irregular immigrants started marching towards Greece, and Greece pushed them back. So is Greece assumed to violate non-refoulement principle in full? What is your idea? Yeah, I was in Turkey during that period. I felt really very upset.
Yeah, and your question points to so many things, right? The freedom of movement and the militarization of borders and the role of the European Union as well. So to answer your question, the principle of non-refoulement prohibits a state, in this case, Greece, to push asylum seekers back to a state or to a situation, to a place where the human rights or the safety of asylum seekers would be violated, right? So it all depends on the conditions of asylum seekers in Turkey. If, let's say, these individuals, asylum seekers who were pushed back by the Greek authorities, were put in detention by Turkish authorities for, let's say, months in terrible conditions, the response will be yes, it violates clearly the principle of non-refoulement. Why? Because the result of this pushback was these individuals being arbitrarily detained, which amounts also to persecution. But if I remember it well, they were just pushed back and then they had no other option but to go back to the cities like Istanbul where they were staying, and they were not persecuted by Turkish authorities, right? So the simple answer to your question is no, it doesn't amount to non-refoulement, but it does amount to a prevention of access to asylum. And the European Union, I mentioned some of the directives they have, and also the case law of the European courts. Strasbourg and Luxembourg says that refugees, asylum seekers should have access to protection. If they leave Turkey and their aim is to access protection in Greece, or in another country, while they should have a possibility to claim refugee status in another country than Turkey. The 1951 convention, when you read it, it doesn't say anything about where a refugee's mobility should end. It doesn't tell refugees, you should claim asylum in the first country of asylum. It doesn't say to, for example, Syrian refugees, oh, you arrive to Turkey, you have to claim refugee status in Turkey. So the 1951 convention doesn't prevent a refugee to then go on and claim refugee status in another country, because it's a case-by-case analysis. It's not about groups, it's about the individual's story, about their persecution, their needs. So nothing prevents, and there are so many examples of refugees who are first established in Turkey or in Lebanon or in other country, then decide to move to another country and claim refugee status in that other country, and they were successful. So I think in that case, it was the responsibility of the Greek authorities and the European Union to say we will let them come and claim refugee status. But unfortunately, we are in a context where these nationalist populist movements are dominating the discourse and influencing the public opinion as well. So if I were a refugee lawyer, I would make a very strong case in favor of non-refoulement and access to asylum.
Abiye'nin bir
Hocam
sorusu var.
benim de sorum var, tekrardan izin verirseniz.
I would like to ask a question too. Please go ahead. At first, I would like to interpret that case. You know that Turkey
Askerlerini İdlib bölgesine göndermişti. Hatta
sent her soldiers to another region. So one day after that, there is an immediate outflux of refugees from Turkey, so to say, and those soldiers were deployed to somewhere where 33 Turkish soldiers were killed. And Minister of Interior, Mr. Süleyman Soylu, said that we will not prevent refugees if they would like to leave Turkey. So we can easily and clearly see that refugee issue is directly connected with politics. And I would like to ask a question with regard to Denmark. And for example, Denmark makes declarations that they will repatriate Syrians who arrived at Denmark irregularly or illegally, because they claim that Syria is no longer a dangerous country. They do not have any threat, any security threat, but the condition in international conventions is that the person, him or herself, decides open that the situation in the home country, in the country of origin, is safe and secure anymore. But Denmark makes its own decision on behalf of refugees or asylum seekers. No, this repatriation should be voluntary repatriation, and Syrians should be voluntary about it, voluntary for refoulement, and they should know what kind of services they could benefit from after repatriation.
So what Denmark is doing would definitely amount to refoulement if these individuals are involuntarily returned back to Syria, and when they return to Syria, they face life-threatening conditions, or they face also extreme poverty and marginalization. So this could also amount to to a breach of the 1951 Convention principles. Yeah, it's extremely worrying, these developments. I believe there will be a complaint before the European Court of Human Rights and maybe the Luxembourg Court as well. But there should be some mobilization and resistance against these kind of, very questionable policies.
Başka sorumuz var mıydı?
Any further questions?
Eğer başka...
If not,
Pardon, Deniz duyalım.
Küçük bir hatırlatma yapayım. Son 9. soru var.
quick reminder only.
Onu soralım.
There is question 9 left. Let's keep it in that way and do not ask it. So it is now after 7 o'clock in Turkey. We could close our session now. This session is a really very important one, makes much sense. It is enlightening for us all, because in the upcoming weeks we would be talking about that in Mediterranean Sea, and also forced refoulement, asylum system, termination of asylum system. We would be talking about all those topics, and this session provides a background and underlie for us all, a basis for us all in legal terms and historical terms, because all those topics which we make mention of are current ones, but they also depend on international law or misconduct of states with regard to legal obligations, or creating exceptions, but mis-exceptions. So this is really very important to start with that session. Thank you very much for having, for spending your time with us, for your time. And I would like to thank you for your patience and attention once again. And also those analyses would be beneficial for making a progress out of sessions to be offered in the upcoming weeks as well. And in case of any questions, you can write me through my email, which is written and on the slides. And I wish you a pleasant and fruitful training program. And now we could end our program. See you.